Evgeny Kiselev, and I'm a television anchor and news analyst. And I have the honor of moderating this panel devoted to the issue of Ukraine and its ability to legally sue Russia for the different damages that were inflicted on her since 2014. We have a number of distinguished panelists, and let me introduce them to you. Here we have Anders Aslund, my old friend, whom I know from probably the early 90s when I was still working in Russia, and he was one of the advisors to the then democratic Russian government that was directing Russia in the right way. Unfortunately, that was very, very long ago, wasn't it, yeah. Anders? And we also have here Olena Zerkal. I'm sorry, I was very nervous when I was thinking that I can probably not make it for the start of the panel. Olena Zerkal, the Deputy Foreign Minister of Ukraine, who is in charge of all the legal issues and all the legal process related to the topic of our discussion today. We had a very interesting interview with Olena several weeks ago that was televised in Ukraine about her struggle, and we also have Chief Executive Officer of Naftogaz Ukraine, Yuriy Vitrenko, also one of my best speakers on a number of programs, and we had some very interesting discussions with him. We also have here a representative of Covington and Burling, the world-famous legal firm that is, as far as I understand, helping Ukraine in a number of litigations. And Eugene Czolij, do I pronounce your name correct? Eugene Czolij is I'm sorry. Yes. I'm just looking at my notes and I can't find the. So, as far as I understand, we have 12 minutes reserved for every speaker. And the first one will be Anders Aslund, who is going to try to sum up everything related to the possible ways of litigating with Russia. Thank you.
Thank you very much, Zhenya. Great pleasure to see you as always. And please. What I would like to talk about today, that is this report that we put out early this year, Kremlin aggression in Ukraine, the price tag. So I will talk about how much did it cost, and all the other lawyers here, they will talk what can we do about it. So that's the distribution of labor here. So how much has Ukraine lost in terms of stocks and flows from the war with Russia. And I'm not discussing the military costs per se at all, more the human costs. I'm discussing assets, what it has cost economically. But to begin with, perhaps we should look up on how much does this war cost Russia. There is a sense that Russia has always massive resources, which is not necessarily true. The Russian GDP is about $1.5 trillion, while the US GDP is about $20 trillion, and the EU is about that much. So Russia is a small country in this context. Russia has spent enormously on its preparations for wars. From 2008 to 2016, Russia increased its military expenditures by 2% of GDP, by $30 billion, which is a lot of money. And how much do the Western sanctions cost? The IMF made an assessment that the financial sanctions would cost 1 to 1.5% of GDP, and I think that holds pretty well. The financial sanctions are the ones that really cost, and to that comes the cost of administering Crimea and Donbass. There are official budget numbers for Crimea. They are now down to $2 billion a year. This is not including the Kerch Bridge of $3.5 billion. And Donbass will probably cost about as much. So say that this is $4 billion. So where does this land us? With 3 to 4% of GDP and $45 to $60 billion a year, which is a lot of money. And this is annual expenditures for Russia to pursue its increased war activity and the cost of sanctions. So what you can say is that Russia is condemned to economic stagnation as long as it pursues its war with Ukraine. This is how the policy choice should be formulated in the Kremlin. No reason to believe that it is, but therefore it's serious. So then, over to how Russia manages Crimea and Donbass. The management is completely different, but you're probably aware, but I just want to hammer in the points. Crimea is a part of Russia for all administrative purposes and legal purposes. It is fully annexed. What is happening in Crimea is done according to Russian law, however that law happens to be. Donbass, nobody is responsible for Donbass. Nobody recognizes DNR and LNR, and rightly so. Russia takes no responsibility. When something is taken over in Lugansk or Donetsk, then it is a matter of lawless seizure of assets. There are no laws for it, and nobody is responsible behind. In Crimea, a couple of tens of thousands of people left for Ukraine, and approximately as many came from Russia. There's no significant change in the size of the population. That was 2.3 million before, and it's about the same now. In occupied Donbass, it's a bit unclear because there were no clear borders for the territory, but 4.5 to 5 million people lived there. Now it is half as much. Barely 2.5 million people. So half the population has fled, 2/3 to Ukraine, 1/3 to Russia, and of course we have many people who are spending some time in occupied Donbass and sometime somewhere else. So Donbass is a lawless hellhole, while Crimea is, so to say, normal Russian territory in terms of administration. So then over to the costs. what it has cost. If we take first on the flow side, Ukraine has lost 17% of GDP as it's measured. But when you ask, is this parts measured? The strange thing is that Crimea was just taken off the books, although Ukraine doesn't recognize the annexation, and that was 4% of GDP, which is not counted as a decline in GDP, but it simply means that the GDP is less in money terms. Occupied Donbass was 10% of GDP, as far as we can see, 17% of industrial production. That is gone. So if you take 17% decline in GDP in total, which happened 2015, 2016, 10% comes from that. Then you wonder, and the rest? Well, Russian trade with Ukraine has fallen by 80% from 2012 to 2016. It has recovered a bit the last 2 years. And this is a massive blow to the economy. So this is in 2012, 29% of Ukraine's trade was with Russia. In 2016, 11.5% of Ukraine's trade, and the total trade was then half as large. Apart from the trade, which has largely declined because of trade sanctions, mainly Russian sanctions, but also partly Ukrainian sanctions. 1/3 of Ukraine's export to Russia was armaments, mainly parts of armaments. As the Ukrainian tend to say, Ukraine did not have a military-industrial complex. It had a large military industry that was part of the Soviet military-industrial complex that until 2014 essentially stayed intact. And this should also be a big cost for Russia that is not being discussed. For example, all helicopter engines of Russian helicopters were produced by Motor Sich, headquartered in Zaporozhye. And many of the parts of S-300 and S-400 were produced in Kharkiv. So this is also of importance. But the trade disruption could explain the rest. Then on top of that, you have that there is very little investment in a country in a war. Ukraine used to have foreign direct investment of close to 4% of GDP, regardless of Yanukovych, etc. And in recent years, the real foreign direct investment has been about 1% GDP. So it's about 3% of GDP, and you can directly take that from the growth that has been taken off. So from this perspective, Ukraine has performed quite well. Over then to losses. How much is it? I think that the best way of looking upon the overall losses, it is to look upon how large are assets in a country normally in relation to GDP. These things normally don't vary much. Thomas Piketty's grand book, Capital in the 21st Century, assesses that assets as a share of, as relation to GDP have been 4 times GDP on average in Europe for the last 140 years. So this is a good number to use. It's very surprisingly little. So we just take how large share was it of GDP? 3.7% of GDP in Crimea, 10% in occupied Donbass, that's the 13.5%. How much was GDP before the conflict? $180 billion in 2013. And we multiply that with 4, and we get almost $100 billion. So this is a reasonable assessment of the total assets that Ukraine has lost because of the war. Most of this is in Donbass. about $750 billion. What can we do about that in terms of legal settlement? Nothing for the time being, because nobody takes responsibility for Donbass. This should be a big part of any future peace settlement. You will hear, of course, say that Russia would have to pay reparations, and Russia would say, why would we pay reparations? So this is a big, outstanding question. Moving to Crimea, there is actually a legal situation. Russia has taken responsibility for it, the territory legally, and things are done according to Russian law. So the Russian government is fully responsible. There is a bilateral investment treaty between Russia and Ukraine that is in force of 1998. So there is a basis to sue Russia. And who can sue? Well, Ukrainian enterprises that have lost their assets. And the biggest one is here represented by Yuriy Vitrenko. Naftogaz claims, with all its subsidiaries, $7 billion in permanent Hague. The Privat Bank, now represented by the state, claims $1 billion for assets it lost. Oshad Bank, the biggest bank, claimed $1 billion. And System Capital Management, Akhmetov's company, claims another $1 billion. So there are at least $10 billion of claims that are now in the permanent court of arbitration in The Hague, and four others. One has already been won by a Kolomoisky-based group, and the problem is it costs a lot. It takes a long time, and it's difficult to claim the assets. Well, then we have other assets. There are 1.4 million hectares of agricultural land that has been taken over by the Russians. What can you do with that? Nothing for the time being, because there's not sufficiently big owners that they can go to court. And then you wonder about the government. That's for Olena Zerkal to answer. But the problem is the Ukrainian government cannot claim things if it doesn't recognize the annexation, which it, of course, does not. So altogether, we can now see that $10 billion is being to claim from the Russian government on bilateral investment treaty, and much more should come into question whenever there is a settlement of over Donbass. And with that, I leave it to the lawyer participants on the panel. Thank you.
Thank you, Anders. We had a coup here while you were talking, because we changed, we agreed that we're going to change the order of our speakers, and the next will be the top lawyer who is represented here on the panel, Jeremy Wilson of Covington and Burling. Jeremy.
Thank you, Evgeny. And Anders, thank you for introducing this very interesting concept of bilateral investment treaties and how they're being used by Ukrainian companies and Ukrainian investors in order to seek redress for their assets that were expropriated in Crimea following the purported annexation in 2014. Now, as you heard, I am a lawyer at Covington and Burling. I'm one of the co-chairs of the International Arbitration Practice, and we are advising and representing Ukrainian companies in claims against the Russian Federation. My colleagues are also working very closely with Ms. Zerkal and the Ministry of Foreign Affairs in a claim before the International Court of Justice, as well as on a matter in arbitration under the UN Convention on the Law of the Seas. So like our colleagues on prior panels where they said that they were limited on what they can say, I suffer from the same restrictions because these are very sensitive cases. They are ongoing, and so I'm not going to be able to delve into the specifics, especially the cases that I'm working on, but I can give you a background on the bilateral investment treaty, how they work generally, some key provisions in this treaty between Russia and Ukraine, and then some of the issues that have been reported on in the press. And it will shed some light as to how claimants are going about seeking redress again for their assets that have been expropriated. Now, just one point that has been noted in the press, so I can say this, and it's of interest. The Russian Federation has refused to participate in these proceedings, and they have claimed that the investments at issue do not fall under the protection of the Russia-Ukraine BIT, and in its correspondence with the Permanent Court of Arbitration, Russia has argued that these claims cannot be considered under the BIT, and it has noted that it does not recognize the jurisdiction of the arbitral tribunals that are deciding these cases. To date, this position has not found any legal support in any of the decisions that have come to light. Now, I have to note again that these decisions remain confidential, but they have been reported on in the press. So what I want to do first is just give you a brief overview for the non-lawyers in the room as to how these bilateral investment treaties work. Now, a bilateral investment treaty is an agreement between states setting out a legal framework as between those states for investment and investment protection for individual nationals and companies of one contracting state that invests in the other. And the broad purpose of these treaties is to foster economic cooperation between states and encourage investment. And as Anders mentioned, the treaty at question here, the one between Russia and Ukraine, went into effect in 1998. Now, they offer, these BITs, substantive protections for the benefit of investors. And while the terms of BITs will vary, and there are thousands of them across the world, most invariably what you find is that they do offer a protection to investors of an unlawful expropriation by the contracting state. In addition to these substantive provisions, these BITs also allow for compulsory arbitration where there has been a violation under that BIT. And that is one of the things that is, I think, most remarkable about modern bilateral investment treaties. An investor can, on its own, go to a tribunal and seek redress, where historically it had to rely on a state to represent its interests. And as a result, we've seen in the course of the last decade and a half a huge uptick of investors seeking compensation for the expropriation of their assets or where there has been a breach of a fair and equitable treatment standard where, for example, there's been some sort of discriminatory behavior against a particular investor. Now, turning to the Russia-Ukraine BIT. As I mentioned, this one was executed in November of 1998, and it provides the investors from each country with possible recourse to international arbitration where there has been an alleged violation of their rights in the territory of the host country. The Russia-Ukraine BIT applies to all investments made by investors of one contracting party in the territory of the other contracting party on or after the 1st of January 1992. And so for any investor to seek or attain redress through investor-state arbitration under this BIT, it must establish that the tribunal has proper jurisdiction to hear the claims under that BIT. And specifically in relation to the Russia-Ukraine BIT, they have to, the investor, give at least 6 months' notice in writing to the Russian Federation. The claimant has to qualify as an investor as defined under the BIT, and the claimant must have made an investment as defined under the BIT. So before an investor can commence an arbitration against the Russian Federation, it must provide written notice, and it must give 6 months to endeavor to settle the dispute through negotiations if possible. It will come to no surprise to all of you that there have been no successful negotiations. Once that 6-month period lapses, you can then commence and file your written notice of arbitration. So now addressing this question of investor. Under this specific bit, an investor is broadly defined, and it encompasses both natural persons and legal entities that have citizenship in the state of one of the contracting parties, and who are competent to make investments in the territory of the other contracting party. Now, investors must be competent in accordance with the legislation of their home state to make investments in the territory of the other contracting state. In terms of the definition of investment, it can be any tangible or intangible assets which are invested by an investor of one contracting party in the territory of the other contracting party in accordance with its legislation. And this can include movable assets, immovable property, as well as any other related property rights, and rights to engage in commercial activity, including, and this is very important for our client, Naftogaz, the rights to exploration, development, and exploitation of natural resources. If a Ukrainian investor is able to satisfy these requirements, a tribunal will have jurisdiction to consider the merits of an investor's claims that its rights under the BIT have been violated. So now turning to the substantive provisions of this BIT. The Russia-Ukraine BIT contains various substantive investment protections, and notably the one that is of relevance for the Crimea-related claims is the protection from expropriation. Now, unlawful expropriation, like in most BITs, is not defined, and we look to international law and also precedent from other investor-state cases. The BIT, however, does prescribe the circumstances in which the expropriation will be considered lawful as opposed to unlawful, and it provides the following test. It needs to be taken in the public interest, under the due process of law, not discriminatory, and accompanied by prompt, adequate, and effective compensation. And these conditions are cumulative. And accordingly, a contracting state's failure to meet any one of these will render an expropriation unlawful. Now, another notable feature in the Russian-Ukraine BIT is that it also includes what's called a most favored nation provision. And effectively what this does is that it ensures that a contracting party will offer a treatment that is no less favorable than that which it accords its own investors or to any investors of a third state, which means that if you are a claimant and you have fulfilled the jurisdictional question, you have shown that you are properly an investor and you have made an investment and you've brought a claim, you can look to any other BIT that the Russian Federation has with a third country and import those protections into this BIT. So for example, if there is a fair and equitable treatment standard in another BIT, that can be imported through the MFN clause. So now turning to the Crimea-related claims, and I mentioned this at the beginning, what I'm going to disclose now is just what has been reported on in the press. We have more information, but given the fact that we have these matters ongoing, I can't go into them in detail. Unsurprisingly, many of the cases have involved a detailed consideration as to whether the tribunal has jurisdiction over its dispute, with many of the tribunals actually bifurcating, so dealing with this question of whether there is properly an investment in the territory, and then dealing with questions of liability and quantum at a later stage. And some of the public reports shed some light onto some of the issues that the tribunals have considered. Now, while the tribunal's reasonings in these cases have differed, the issues that they have considered are similar. And a key question for the arbitral tribunals has been whether the claimants had protected investments under the terms of the bilateral investment treaty. And in answering this question, they dealt with two issues. First, whether Crimea constitutes the territory of the Russian Federation, and this is important, for the purposes of establishing jurisdiction under the BIT. And secondly, whether the BIT may extend to investments that were originally made in Ukraine, prior to the purported annexation in March 2014. So on the question of whether Crimea constitutes the territory of the Russian Federation for the purpose of establishing jurisdiction, one tribunal held that the BIT applied to the entire Russian territory, and the tribunal did not address the question of whether Crimea was Russian territory as defined in accordance with international law, noting both that Russia and Ukraine agreed that the BIT applied to Crimea, and that the treaty had always applied to Crimea. And in a non-disputing party submission by the government of Ukraine, it maintained that while Crimea remains part of Ukraine's territory, that for the purposes of this dispute and for the purposes of the BIT, the Russian Federation's current occupation means that Crimea is presently part of the Russian Federation for the purposes of the bilateral investment treaty. Another tribunal concluded that the BIT's protections were intended to cover the entire territory under which the Russian Federation had effective control, whether or not such territory was lawfully occupied. In addressing the second question, whether BIT protections may extend to investments originally made in the territory of Ukraine, one of the tribunals concluded that, among others matters, the object and the purpose of the BIT supports the extension of its protection to such investments. And another tribunal concluded that the BIT contained no requirement that investment be made in the territory of the other state at the outset when that investment was originally made. And interestingly, tribunals have addressed this question of Russia's non-appearance as a preliminary matter and have taken the view that they have the power to decide and consider on their jurisdiction. So there have been these cases that have at different stages. We note that there have been some jurisdictional awards in favor of the claimants, and there is only one case that's been reported on so far, and that is for Everest Estate, which relates to property, both commercial and residential property, that was expropriated, where there has actually been a final award on quantum. And I note that this award remains confidential. But ultimately, I think what is really important, and the reason that this factors into this discussion today, is that Ukrainian investors do have a means to seek legal redress as their own individual entities. They have the power to go in and sue the Russian Federation, and we have seen a flurry of activity over the course of the last 3 years, and I expect we will see more as more investors learn about their rights under this bilateral investment treaty. Thank you.
Thank you very much. Our next speaker is Yuriy Vitrenko, the Chief Operating Officer of Naftogaz, which is the major Ukrainian company in the sphere of gas extraction and transportation, and a company that recently had shown some brilliant results in their operation. Yuriy,
do I need
the
to
floor
go
is
to the
yours.
podium, or I can sit here?
You choose.
Okay, I would rather stay here. Maybe again, I would also like to consume less of your time giving a speech and to give more time to questions, so that it's a little bit more interactive, because after lawyers speak, sometimes some interaction would not hurt.
Nobody's volunteered.
So, as it was already mentioned, Naftogaz, on one hand, sues the Russian Federation for assets that Naftogaz Group had in Crimea. And Naftogaz Group means that it's not just Naftogaz as a separate legal entity, but also subsidiaries of Naftogaz, most notably Chernomor Naftogaz. we had a subsidiary that was located in Crimea that produced and transported gas and had some retail network in Crimea. As it was mentioned, the total value of the claims for this particular case is roughly $5 billion without interest, and with interest it's now more than $7.5 billion. Maybe the number is not that impressive for people from the UK, but for you to understand the magnitude of these numbers, you should recognize the fact that Ukrainian GDP is roughly $100 billion. So when I say, for example, $7.5 billion, it's roughly 7.5% of the GDP. And then you understand the magnitude of even this particular claim. How important is that? I would not go into legal details. First of all, I'm not a lawyer. Second, I don't want you to go into sleep, to hibernate. And second, again, we have some limitations, as Jeremy mentioned. So I would be, again, happy to take your questions in this respect without revealing too much details. But Jeremy, as a lawyer, very diligently and accurately described the underlying legal position for us to sue the Russian Federation for our assets in Crimea. I would also mention another arbitration, not against the Russian Federation as a state, but against Gazprom. Probably heard about that. Gazprom is, for those who did not hear about Gazprom, Gazprom is a Russian gas company, one of the biggest in Russia and one of the biggest in the world in terms of oil and gas companies. And recently we finished 2 arbitrations against Gazprom. At least our lawyers say that we had the biggest commercial arbitration in the world history, with total value of claims from both sides exceeding $100 billion. So this arbitration was based on 2 contracts signed in 2009, negotiated between Yulia Tymoshenko, the Prime Minister of Ukraine at that time, and Mr. Putin, the Prime Minister of the Russian Federation at that time. It was a contract, long-term contract for 11 years. At that time, the biggest long-term contract for supplies of gas and transit of gas in the world. And then his contract was still notorious for many details, but basically in 2014, when Ukraine decided to, how to say, not to depart from like the Russian destiny or legacy, whatever you call it, but then Ukraine at least tried to show that Ukrainian people made their independent choice in terms of European values, again, integration into the European Union, and embracing, I would say, the modern civilization. In general, again, the Russians decided to retaliate, and one of the fronts, in addition to the military front, to the military aggression, and the legal front, was the energy front. So they waged an aggressive energy war against Ukraine. So almost overnight, they increased the price of gas almost 2 times. And they claimed more than $20 billion in so-called take-or-pay obligations. So under this contract signed by Naftogaz and Gazprom, but negotiated between Yulia Tymoshenko and Putin, Naftogaz was obliged to take huge volumes of gas and pay for that regardless if it uses or not. And it seemed like on the surface that it's a more or less standard European contractual rule or term, basically, to have the take-or-pay clause in the contract. And that's why many observers, again, all over Europe and all over the world, they would say, look, again, Russians are not doing anything wrong, that just they follow the contract. So again, maybe it's Ukraine who is not reliable, or Ukraine is in some dire state and needs some help, but it's not that Russians are doing something wrong. And we proved in the court that in fact there was something fundamentally wrong about the contract. And this particular clause, for example, fast forward, this take-or-pay clause was recognized by the tribunal as being not just excessive, but unreasonably excessive. That recognizes the fact that something that was portrayed as a European contract or some kind of new European relationship in the gas sector between Ukraine and Russia, in fact, just was there to hide, to some extent, like a near-colonial policy of Russia towards Ukraine. And as soon as Ukraine started to basically change the status quo, Russia retaliated using, for example, gas supplies as a weapon. So the legal term that the tribunal used was unconscionable. So these provisions of the contract were recognized as unconscionable. Then also, probably you heard or not, so the total value of this take-or-pay claim, so it started from $20 billion in 2014, but as of at the end of 2017, the total value of this take-or-pay claims exceeded $60 billion. And if you also include the take-or-pay claims for the remaining years of the contract, 2019 and 2018, it would be in total more than $85 billion of just the take-or-pay claims from this contract. Also, again, also fast forward, as I mentioned, we managed to prove in the arbitration that this contractual provision was unconscionable, and that's why the tribunal ruled that we should not pay anything to Gazprom under this provision, and they revised the contractual so-called take-or-pay volume to a really reasonable level that basically is equal to 50% of our import needs. For you to understand, it's from more than 50 billion cubic meters per year to less than to 5 billion cubic meters per year. And out of this 5 billion cubic meters per year of annual contract volume, 4 billion cubic meters are take-or-pay volumes. Now I see that people are falling asleep because of my, again, guest speech, so I'll try to stay more political. It's not easy for me because, again, I'm from a gas company. Also, but maybe billions that we already won can excite the audience, and at least it will be more lively. So we successfully defended against $85 billion of claim from Gazprom for take-or-pay clause. Then from our side, we claimed the price revision, and we were basically proving that the price, although it was called as a European or market price, it has nothing to do with the European market prices, and we were successful in our claims. So due to price revision, again recognized by the tribunal, we won roughly $2 billion. Then, as I mentioned, we also had a transit contract, and under this transit contract, we claimed so-called under-deliveries. So we basically claimed that Gazprom did not follow the contract and did not compensate us for damages that were resulting from the fact that they were under-delivering volumes for transit. And we successfully won $4.6 billion from Gazprom in damages. Again, $4.6 billion, it's 4.6 or roughly more than 4% of Ukrainian GDP. So you can understand the magnitude again of these numbers. Now, as you know, Gazprom is not paying, so they do not recognize this decision of the tribunal. That basically proves that when Russians say even companies, again, like Gazprom, that try to portray or position themselves as, again, companies playing by the rules here in Europe, in fact, they pay just lip service to European rule of law. So they don't now fulfill the decision of the tribunal. They don't pay us $4.6 billion. We started an enforcement procedure in different jurisdictions, including here in the UK. It's in Switzerland, in the UK, and in the Netherlands. And in the next couple of days, I hope you will hear some new announcement about new jurisdictions. So in these jurisdictions, we were successful in getting freezing orders or some suspension on their assets and their rights, basically, in respect to their assets. They tried to challenge it in the Swedish courts, in Svea Court of Appeal. They failed. Again, they were using funny arguments like the tribunal did not write the decision, it was the secretary who wrote it on behalf of them. It was really a funny argument because we had one of the most distinguished tribunal, again, consisting of the former head of the Swedish Supreme Court and other very distinguished lawyers. So I know that they know the rules and they would follow them. But again, to cut a long story short, it shows that with our example, that when Russians and Gazprom in our case say that they follow the rule of law, again, as I said, it's not more than empty words. And if and when they are held to account, they would fight till the very end, again, using really something that you would not expect from a reasonable side. Again, I cannot go into all the details of the arbitration, but I was personally like a witness of all the tricks that they played. And then basically it's just a matter of the strengths of the legal or judicial system here in Europe that can enforce the rule of law. Because at least it was my personal conclusion out of this like 5 years spent fighting against Gazprom, that they recognize only the power and even, for example, the power that is based on the rule of law. So we should expect that the rule of law should show here its power and strengths and its force, and only then we can, in such a way, we can hold Russia to account.
So, thank you, Yuriy. And so our next speaker is Olena Zerkal, Deputy Foreign Minister of Ukraine, who is trying to hold Russia to account, who is in charge of all legal claims of Ukrainian government against Russia in international tribunals and international courts. Olena, the floor is yours.
Thank you, and I will try not to let you fall asleep as well. And I will be brief and just want to start from the sentence that I'm very proud that we already have results of our battle, legal battle against Russia, because we've started this battle in 2014 from scratch, without any legal strategy, without any legal tactics, without any understanding of our possibilities. And first meeting with lawyers we conducted here in London 4 years ago. So since that time I see particular and practical results of our battle. And it's not just a battle for money. It's a battle for us, for our sovereign rights, and definitely for international law as such. Because Russia makes everything possible just to avoid any responsibility. And they try to be not limited by any kind of rules. They know exactly all holes and all aspects of international law, and they're very good in pursuing their narrative. And definitely for us, the main issue is to ensure that justice will be restored. Of course, this is not an easy task with a permanent member of can't easily make Russia reliable or liable for the aggression and the aggressive policy it conducted with Ukraine. But definitely we try to use international law with all its limits. And my colleagues, which has already presented their results in private law domain, showed us that these results are possible, despite the fact that in 2014-2015 there were a lot of doubts concerning the possibility of use of this bilateral treaty for investment protection, especially taking into account this unclear status of Crimea and position of Russia, which did not want and still does not want to participate in any litigations. But at the same time, I will focus on our work we have with public international law domain, where we are more limited in our possibilities to protect ourselves, but despite this fact, we are also quite advanced, because next year, next June, we will already have hearings on jurisdiction on law and the Sea Convention. And we went a long way, and we conducted all necessary consultations and pretrial procedures, and then created an arbitration, submitted our memorandum with all our claims and with all our legal position, and definitely it was a huge work behind this. I've never ever expected that it would be so difficult to collect all evidences and to actually submit this memorandum to the arbitration. The same situation we have in ICJ, where we tried to sue Russia on two fundamental treaties, the Treaty on Suppression of Financing of Terrorism and Elimination of all forms of racial discrimination. We had a preliminary judgment concerning we had judgment on preliminary measures last year, and we still actually did not receive a positive result with its implementation, because Crimean Tatars still can't actually have a right on self-determination and self-governance, and the ban on Medžlis still exists, and Russia refused to implement this ICJ order. But I do believe that we all make the same job. We protect international law as such. I know that in the current circumstances, especially after the recent decision of United States to terminate treaty with Iran, a lot is put under the question concerning the future of international law. But I think it also creates for us, for those who suffer from aggression, a question and necessity to join our efforts in order to protect international law and to ensure that it works. We have a very long-standing and not easy struggle with Russians in these battles in international forums. And definitely there are a number of issues which can't be addressed by the international law. However, we still believe that this is the only way we can pursue in order to restore justice. And we don't have any other possibility except military and diplomatic. At the same time, we know that pure diplomatic efforts, they just don't work. We had a broad legal basis of our relations with Russia, more than 400 treaties, without any possibility of creation of arbitration and any possibility of dispute settlement with the use of arbitration, only with diplomatic means. And there is only one treaty, which was now mentioned by my colleagues. This is a treaty concerning investor protection. And that's where we see the opportunity for investors and for the private citizens to protect their rights, their losses, their actually future possibilities to make Russia accountable for these losses. And definitely, we think that with the use of number of treaties, we may protect our interests. And the recent case and the recent decision of London Court of Appeal concerning so-called Yanukovych 3 billion case showed us that justice is possible. We definitely received very positive result. And the decision which has been taken stipulated that if there is no other forum than UK courts where such violation and duress can be a subject of the court decision, the court should address itself this. For us, it's a way forward, because we not once suggested Russians to go to the ICJ concerning the aggression and the violation of these fundamental treaties I just mentioned, but without any positive reaction and without their consent, we won't be able to bring Russia to accountable. Definitely, there are plenty of possibilities to move forward, and there are plenty of ideas how to make Russia accountable. And we would like to use all of them, but we're very limited in our abilities, I mean in the sense of the government. But this is not the case of private investors, and I really much hope that they will come up with different claims against Russia, and Russia will be brought to responsibility. Thank you.
Thank you, Olena. And now, the final speaker on this panel will be Evgeny Czolij, who is, on the one hand, the president of World Congress of Ukrainians, World Ukrainian Congress, and on the other hand, he is a renowned lawyer from Canada, from Lavery Lawyers. Please.
Thank you, Evgeny. My predecessors said that they will try not to put you asleep, and they've succeeded. I cannot afford not to put you asleep because I'm the last speaker. And somebody once told me a story about a speaker being last and speaking very long. And at the end of his speech, there was only one person left in the room. So the speaker got up and shook his hand and said, "Thank you, sir, for being here till the very end and listening to me." And the participant said, "Actually, I was not listening to you. I'm next."
Good one.
On this one, on the claims that are possible, there are various claims. Claims under the bilateral investment treaty that Jeremy has dealt with, so I will not get into that. There are claims before the European Court of Human Rights that are possible. Claims under the Geneva Convention. Such claims are applicable in times of war, even to non-combatants. There's only one difficulty, is that it's the UN Security Council that asserts universal jurisdiction over such claims, and one of the 5 permanent members is the Russian Federation with a veto power. And there are claims under the UN Convention on the Law of the Sea, but since Anders has limited himself to damages on land, I will not dwell on that. On the BIT, my only additional comment that I wanted to make to what was already explained to you in a very clear manner by Jeremy is, surprisingly, the Russian Federation does not follow the rule of law even in decisions or agreements that it signed. For instance, the Russian Federation is the first country that has rendered a decision in July of 2015 stating that Russia may not enforce decisions under the European Convention of Human Rights if they contradict the Russian Federation's constitution. And in January 19, 2017, the Russian Constitutional Court came to the conclusion, which should not surprise anyone, that the decision of the European Court of Human Rights on compensation payment of more than 1.8 billion in the Yukos case violates the Russian Constitution and is therefore not enforceable in the Russian Federation. When the International Criminal Court published a report stating that Russia's occupation of Crimea is an occupation, the Russian president signed an executive order withdrawing its signature from the founding statute of the International Criminal Court. So why am I saying this? I'm saying this because if one wins an arbitration award under BIT, a country can then, or actually a claimant can then execute a final arbitration award before all the states that have signed or ratified the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or the so-called New York Arbitral Convention of 1958, which states that each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon. That is the beauty of winning a case under BIT. It's the possibility to enforce it in all the other countries that have ratified, and most Western countries have ratified the UN Convention. I will only dwell on the claims before the European Court of Human Rights, since nobody has talked about that today. Claims can be brought before the European Convention of Human Rights because that convention provides in Article 2 the right to life, in Article 5 the right to home and family life, and in Article 1 of the protocol the right to property. Who can bring actions against whom actions can be brought by contracting parties. Those would be claims by a state. Article 33 provides that. And individual applications can be made by any person, which includes NGO, groups of individuals, associations, political parties, companies. Actions can be brought against a contracting state, and both the Russian Federation and Ukraine have ratified the convention for damages caused in the territories that are within the jurisdiction of the countries that one is suing. So the same difficulty as Jeremy has already explained, where the Russian Federation will most probably claimed before the Human Rights Court that damages caused in Crimea and the Donbass do not fall within their jurisdiction because those countries are still recognized by the international community or under the Yuriy or the legal jurisdiction as being part of Ukraine. But there is case law to the effect that actions or claims caused in a territory that is effectively under the control of a contracting state, that enables a claimant to sue the country that controls an effective territory, whether it is the Yuriy or in-law territory under the jurisdiction of that particular country. So in Crimea, the argument could be made that it is under the de facto or the actual factual control of the Russian Federation, which would enable a claimant to sue the Russian Federation for damages done in Crimea. The same can be done for the 7.2 or more % of the Donbass that is under the control of the Russian Federation. The additional difficulties under this Convention of Human Rights before the Human Rights Court is that Article 35 provides that all domestic remedies must be exhausted before being able to apply before the Human Rights Court. And again, here there is case law to the effect that if such measures are not provided in the legislation of a given country, or if one can demonstrate before a court of law that such actions are perfectly useless, then that exercise is not necessary and the court will forego that provision of the convention. There's obviously a difficulty in enforcing decisions rendered by the Human Rights Court. The convention provides that the ultimate responsibility belongs to the Committee of Ministers of the Council of Europe, and there again it's a question of the international community to do its part in order to ensure that blatant violations of human rights are not tolerated. Unfortunately, Ukrainians have not availed themselves of the remedies in large numbers. The numbers that I have been provided with are that as of April 2018, there were 7 cases under the BIT or the Bilateral Investment Treaty in The Hague and a few more in Geneva and Stockholm, and claims before the Human Rights Court, 5 state cases at the time, and about 3,800 Ukrainian individuals and companies have initiated procedures before the Human Rights Court in Strasbourg. That number is definitely low when one takes into account that over 11,000 people have now died as a result of Russian aggression in eastern Ukraine. Over 25,000 have returned home injured. There are now over 1.5 million internally displaced persons. Over 2,500 people have suffered because of they stepped on a mine, including 240 children. So clearly more needs to be done. I think that I would suggest that Ukrainian authorities with human rights activists, with companies like Jeremy's law firm and others should start looking into quickly organizing an international claims committee or secretariat that would do 3 things. One, would organize an international process of verification of claims, which would include what Anders does so well, in order to quantify the damage. 2, set up legal teams that would litigate such cases. And finally, look for funding, because such claims, I'm not going to surprise you, obviously cost a lot of money. And in some cases, it's just a question of time before the decision will be rendered. It is very clear that the decision will be rendered in favor of the Ukrainian claimant, because the facts are very clear about the Russian aggression and the damages that it has caused. So one can start looking at new and original ways in order to finance that, including litigation funding from international capital markets. I also encourage Ukrainian authorities to perfect the class action legislation in Ukraine in order to ensure that one individual can sue on behalf of all that have suffered. For instance, one Ukrainian on behalf of all the internally displaced persons, the Russian Federation, before the appropriate courts, and then to try executing that before Western countries in order to create a real dent in the Russian budget as a result of its blatant violations of human rights and destruction of property. Thank you.
Thank you, Eugene. So, we've got almost 35 minutes for questions and answers, and so I urge everyone present in this room to ask questions. Please introduce yourself and just say who do you want to answer your question, please. Oh, yes, and the microphone is coming.
John Wilson, I'm a journalist and a member of this institute. I'm also a corporate member of an institute of arbitrators. My question is simple. The winner must always be the party who has the greatest power. Do you agree?
Who's going to take this question? Jeremy, probably.
I would disagree with that assertion, and that's the whole point of having these bilateral investment treaties, is that it enables and it empowers investors who otherwise wouldn't have recourse to bring claims against powerful entities such as states, such as the Russian Federation. So I don't think that is the case, but I'd be curious to hear if any of the other panel members think differently.
I think that the Naftogaz case against Gazprom proves the opposite. Exactly as Jeremy said.
To keep the same, so you've announced that you haven't received any money.
I can, by the way, correct this. We have already received $2.1 billion in the form of gas from Gazprom, based on the decision of the arbitral tribunal sitting in Stockholm. And that proves that the rule-based approach, where the power rests with the rule of law, rather than the law rests with whom has the biggest power or more power, proves that, again, a party like Naftogaz, for example, or Ukraine in this case, can prove that we're right and get compensation from a much more powerful counterparty like Russia or Gazprom, for example, in our case.
And you are talking mostly about enforcement. With enforcement, it is an issue, and definitely not only in Ukrainian case and not only in case of Naftogaz. It's usually a case which should be addressed separately.
Let me take advantage of my position and just ask one follow-up question. Did you receive any money from Russia?
Yeah, we received, again, gas is money for us.
Yes, I'm talking about cash.
That's a more complicated question because we get money from, for example, for our transit revenues every month. And a part of this money, basically, and I don't want to go into all the details, especially there are some limitations, but technically we're getting basically value, some monetary value, as a result of these arbitral proceedings, to be precise.
But shall it be correct to say that there was not a single decision taken and enforced against Russia?
But our decision is not against Russia as a state. Our
No. I'm using the word Russia in a broader sense of word. You know, Russian state and Russian state-owned, or even private companies.
With enforcement, we have not succeeded yet, but with the decision, the final decision, this is one of the decisions which Jeremy mentioned. This is Everest.
Yeah, and I think it's important. In relation to Gazprom, there are enforcement proceedings that are happening right now in the United States, for example. And if you are looking to enforce outside of the Russian Federation, there are means to do that. Now, Is the Russian Federation on some of these treaty cases resisting enforcement? Absolutely. Is it a battle once you've received an award in your favor to go out and enforce it? Of course it is, and this is an ongoing exercise. We are still early days in relation to the Crimea-related cases. We've only had one that's had a final award, which is the Everest case, and there are enforcement proceedings going on in Ukraine as we speak. So I don't want to prejudge whether these investors will ultimately receive full compensation. Obviously, when you have a multi-billion-dollar claim, it's going to be harder because you've just got to go after more assets as opposed to some of these claimants who are smaller investors, who have smaller claims, who may have less challenges just in terms of finding these assets around the world to which they can attach and then enforce against. But I think it is too early to tell now and to make a judgment that enforcement won't be successful. We've only had one final award. And the Russian Federation is going to resist these enforcements, but that is the purpose of the New York Convention, and that's what makes arbitration so powerful. You don't have to rely on going in Russia. You can go to any country outside of Russia that has Russian assets.
Member Rusi from Salisbury, Novatov City. First of all, can I commend to the panel Salisbury District Hospital in case you develop any strange symptoms. My question is for Jeremy. Now, it's been said that Ukraine has absorbed some military industries from Russia, including things that helicopter engines and missile parts. Now, has Russia put a claim through the BIT to Ukraine for any of these assets?
I'll actually let Ms. Zerkal answer that one.
Yeah, we did not actually take anything from Russia, but Russia definitely seized a lot of our assets from Donetsk and Lugansk and moved it to Russian territory. But at the same time, they also invoked a number of cases against Ukraine concerning the protection of their property on the territory which is affected by the conflict, and we are in the process.
But what Mr. Aslund meant is that Ukraine is producing, for example, agents for some Russian military helicopters. It's not that we, again, took their plant basically and somehow occupied it or moved to Ukraine or whatever.
Sorry, let me explain. These are Ukrainian-owned enterprises that previously have exported goods to Russia. And how could Russia claim anything against Ukrainian companies that are no longer exporting things to them? No, it was not.
I'd just like to comment one last on the question of whether it's the most powerful that wins. Clearly, the record of the Russian Federation is a poor one, but as of March of 2018, there were 593 cases out of 2,282 against the Russian Federation that have been closed by a final resolution. So the record is not good, but 593 cases is not
593 out of
2,282. So it is possible to execute, it is possible to enforce a judgment. In Canada, we say that today we live in a world that you can beat City Hall, and I think that this is obviously a difficult battle, it's a long battle, it's a costly battle, but at the end of the day, if the international community wants to stop a country from violating every single agreement, international agreement, starting with the UN Convention and just about any other convention, and to stop to violate with impunity human rights, then the Council of Europe and various other institutions will render and take appropriate steps in order to facilitate and enhance the enforcement of such decisions. Another possibility that is offered to countries that do want to take a progressive step forward is to sign with Ukraine bilateral agreements recognizing certain decisions that are rendered by courts. It would be possible, for instance, to sign a bilateral agreement whereby a country like the UK, Germany, Canada, the United States would recognize decisions rendered by a specific court for violations as a result of Russian aggression in eastern Ukraine or Crimea. It is all a question of political will.
Mm-hmm. Please, gentlemen in the third row.
Thank you very much, everyone. Ewan Grant, Institute of Statecraft. I'm a former VAT inspector who was involved in dealings, a long saga, with the VAT carousel fraud issue at the turn of the century, and therefore I'm very encouraged to hear the references made earlier this morning about the sheer importance of this as an indicator of things going right, and also as an unparalleled intelligence source for who's doing things improperly where, and where the money from that is going. The money is often huge, typically is huge. My question is for everyone, but particularly Mr. Vitrenko. You made a point, I think you made references to cases in the Netherlands, Switzerland, and the UK, if I got it right. Now, coincidentally, of course, we've had our GRU friends in the Netherlands, and they were on their way to Switzerland, weren't they? But seriously, how well coordinated do you think the opportunities are there for joint and separate enforcement? Because it strikes me that's a marvelous opportunity to be effective, but also provide a degree of protective ballast against bilateral Russian retaliation, be that indirect or not. Thank you.
Sometimes I can't go into all the details, so we try to coordinate basically our efforts across the jurisdictions, of course. At the same time, again, you understand that there are separate legal systems, and again, local judges made their decisions based on their understanding of what is right and what is wrong. At the same, having said that, even as a procedure, basically, our lawyers would submit some analysis of what's going on in other jurisdictions, and it's our understanding that judges all over the world look at least in proper countries, with the rule of law, in this particular sense, proper, they would look at what others are doing. But also, sometimes it makes some practical sense. Like, for example, in Switzerland, we tried to freeze shares of Nord Stream, and the Nord Stream is a Swiss-based company, so we could not find them in the office of Nord Stream in Switzerland. But when we had a freezing order out of the English court, we found shares of Nord Stream in the UK subsidiary of Gazprom. So even from this perspective, it just... Yes, they liked, by the way, the UK for many reasons, as you can imagine. Hopefully, it will get a little bit more different for them after Salisbury and other events. But they're very comfortable with this jurisdiction and, again, kind of environment. But, I mean, so far, there is nothing for us to complain about the judicial system and courts in particular in all the jurisdictions where we sued Gazprom. So in Sweden, in the Netherlands, in the UK, in Switzerland, we really see some real justice, despite the fact that Gazprom is much more powerful. They are using all the possible tricks and impossible tricks, but we're still winning. So for us and for people in Ukraine, by the way, and here I would be a little bit emotional, because many people went to streets basically to protest against the old system, and they really, it's not that they really wanted to join the European Union, so they just wanted to live in a fair world, where they can see some fairness and again, and justice. And they believed, yes, it based on the rule of law. And basically, they believe that over here you have it. And at some point, they were frustrated, and people are still frustrated when they see certain cases that are contrary to their belief. But for example, in our particular case, we demonstrated that you have this rule of law that you can be really proud about, and now it's just a matter of enforcing, basically, it to an extent when Russia is really held accountable.
The lady in the third row here. Yes.
Hi everyone, amazing presentation from everyone, thank you so much. And I was particularly touched by comments made at the end by Evgeny Czolij, sorry if I mispronounce.
Czolij.
Yeah, apologies. I was awaiting as logical conclusion to Ukrainian loss of assets to add to it human capital in direct and indirect way. We talked about official figures of at least 11,000 people died, killed. Obviously, we talk about much bigger number of injured people, injuries you can see, and how many people who are mentally injured. You know, I had a lot of discussions with people who run businesses in Ukraine, who are in power. Huge national loss. So if we kindly go back to figures produced fantastically by Anders Aslund about how Ukraine should compute its loss before we make next logical step to take, unfortunately, our ex-big brother, Russian Federation, to international courts. I would kindly suggest to include into these figures, by definition, loss of nation by certain percentage. If we talk about 44 million going down to 37 officially, I think it's a huge loss. It means not just loss of life, loss of productivity. Every person who left country is lost to a country because we don't produce domestically. Another point is growth of GDP, not just actual figure deduction, but loss of growth. That's my high-level observations, and I think it's an amazing panel, and I would love to have it longer. Thank you.
Thank you.
So, please.
Question to anyone, comment to anyone, if you wish to comment.
That was more of a statement than a question. No, that's fine. But we welcome any questions here.
All right, thank you very much for the very interesting and detailed presentations. I'm Olga Onuk, I'm an associate professor at the University of Manchester. And this might be sparked by the recent conversation I had with one of my PhD students, so I apologize. But Anders, maybe as an economist, this will spark some interest in getting a reply from you, but a question to all of you. So we've been talking with my student about the game theoretic approach in terms of resolutions to this conflict and various arbitration processes as part of that. So we started off by the costs to Russia, yeah? And that's one way of looking at this, right? That this could be this comes at a cost to Russia also being participant in arbitration processes. But my question to you all is, are these is this a pursuit about asset recovery? And is that asset recovery for the state or for private entities? Is this about punishment, punishing Russia, incurring further costs by being party to this arbitration? Or is this a normative element, right? Is this just the right thing to be doing, even though it comes at a great cost to the Ukrainian state to pursue a variety of these legal actions, right? So that's something I think that hasn't been touched on, and I would be interested to hear your opinions on.
If I may, I would start from the point that for us this is about the sovereignty. And definitely, first of all, we protect our sovereignty and we protect our rights which were violated. And definitely this is the main purpose of our actions, and we are eager to pay the cost because we definitely believe that this is the only one relevant way how to protect our rights. and how to restore our rights. As for the investors and for the arbitration, this is a kind of second layer. Definitely, we mostly focus attention on the rights than on money. But for investors and for actually private citizens, for them, it's about their losses in terms of financial losses and in terms of other losses which just your neighbor mentioned. And definitely here we also support them, because for the investors in each and every case we submitted our amicus brief concerning our state position on Crimea. With European Court of Human Rights, we support those who initiate claims there, and we also have few claims against Russia as a state-to-state. But definitely the cost is incredible, and a lot of investors in Ukraine are not in the position to submit these cases because of their cost. And we have not found the way how to address this issue yet, because it's up to investor to decide whether or not it's a relevant way or not.
But I also believe that, first of all, again, as you could see from our presentations, we are talking about serious money. So, for example, again, just to reiterate, just for our Crimean assets, the value of the claims is roughly 7.5% of the GDP. So again, if you just, for example, extrapolate it on UK GDP, you would be talking about hundreds of billions of dollars. And for Ukraine, again, it's a difference between at least some kind of economic growth or a severe economic crisis. Also, we should not forget that as in every war, it's not just about offense, it's also about defense. So we have to defend against legal claims from the Russian side. For example, in our case, as I mentioned, they claimed more than $85 billion, so like roughly our GDP from our state-owned company, from Naftogaz. Or, for example, they're claiming $3 billion of so-called Yanukovych loan. So for us, it's not just like we want to punish them just for the sake of punishing them. And also, again, sometimes we have to be very careful, starting from being like cold-headed so that we can successfully win in court, and also finishing that, and again, to win in courts you have to focus, and you don't need to be emotional or sometimes even like being provoked by the other side. But also, again, we believe that in order to hold Russia accountable, it's important to show to everybody that it's not just about, for example, like one side of the problem, like be it human rights or even, again, casualties, because then they can always say, look, again, just collateral damage or whatever. It's really important to show that from all the aspects, they are breaking the law, and that's why they should be held to account.
Let me just add here, this is of course to push for rule of law in general, which is a fundamental values. It's not only sovereignty, it's also rule of the law in the world, and that international law matters. On the strictly financial side, the total Ukrainian costs in these regards cannot have been more than $100 million, while Naftogaz has already collected $2.1 billion. So if you take the total legal cost for Ukraine and the total gains already, it's an obvious benefit financially. Thank you.
I'd like to thank the person that spoke before that pointed out to the importance of the human factor. I last summer had the difficult task of shaking the hand of a 22-year-old widow that was standing with her two children of 4 and 2, and they are looking to see, are we living in a world where a barbaric conduct goes unpunished or not? I shook the hand of a father that buried his son. They're looking to see, if we live in a world that is truly modern, that respects human rights. And I think that it's time for the international community to not only look at Ukraine and say how much has it reformed or not reformed, whether they complied with this or that requirement, but to look at it and to see that it is today the object of a vicious Russian hybrid warfare. And it's up to the international community to ensure that Ukrainians are protected like everyone else. I think that when 240 children step on mines and go either are killed or injured for life, it's not a question of punishing the Russian Federation. It is to ensure that we live in a just world. And if we want to live in a world that is superbly dangerous, then we will allow the Russian Federation to go unpunished for the gross and blatant violations that it causes. Today, or actually in 2017, notwithstanding the Minsk agreements, if one takes a look at the OSCE reports, there were 401,000 violations of the ceasefire. 401,000. That is 1,100 violations per day in 2017. So it's not a question about punishing anyone. It is to ensure that Ukrainians can live in peace in a world that they have determined, in a course, in a direction that they have chosen, and to ensure that the international community, that agreements such as the Budapest Agreement and other agreements where we give countries the assurance that the international community will support. And when we talk about a big game about fundamentals and values today, this is where the international community is being directly challenged by the Russian Federation. It's not just about Ukraine. It's a question whether we want to live in a secure world or not. Because I tell you one thing, if we look at it from the other perspective and look at it just from a perspective of Ukraine, what will happen, definitely what will happen, is that if Ukraine should, God forbid, not be able to secure its borders and stop Russian aggression, Russia will go further. And then it will attack either the Baltic countries or Poland, both covered by NATO's agreement in Section 5 that provides that at that stage it's an attack against all NATO countries. And ladies and gentlemen, we will be at that time facing the Third World War. So it is in the best interests of every person living in London, as much as it is for every person living in Donbass, to ensure that Ukraine wins this war and ensures peace and security in the world.
Thank you. Anybody else from this panel on this particular issue? If you allow me to add just a couple of words. You dwelt upon a very important issue, as a matter of fact, speaking what it is normal, legal, international practice, assets recovery or punishment. And I completely agree with Mr. Czolij that it's also about punishment. I'm convinced that Russian government, I'm not talking about Russian people, I'm talking about a Russian government. I'm talking about this regime of Vladimir Putin, who is viciously, unashamedly, brazenly ignoring international laws and showing daily disrespect to democratic values on which the civilized world relies. And here, a lot depends on the political will of Western leadership, because, in my opinion, I completely agree with you, Eugene, that it's not just about Ukraine. It's about Europe. It's about this country. Men and women were already killed on British soil. Remember remember Salisbury, remember other cases when men who asked for political asylum here against Putin's regime were also killed. Holding Russia to account, it's about justice, but political will is involved. This is issue number one, because for a very long period of time, Western leadership was trying to do what was called appeasement. If you remember appeasement of the late 30s, you remember what came out of it. And appeasement will no longer, never work. Remember that. Thank you. Other questions, please? Well, probably.
I think you had a question down there.
There's a question over there in the back.
Yes, sorry, this gentleman here.
Oh,
I cannot see some.
Shall I take a question?
I'm sorry. You will be the next.
Yep. John Mason, RUSI member. If it was possible to draw a comparison with the current discussions and the Yugoslavia crisis, if there were comparisons, are there any lessons to learn from that, and any predictions of what might be, how it might, the future might look, how it might resolve, etc.? Thank you.
I would argue strongly against that. Yugoslavia was real separatism. In Ukraine, we are seeing Russian aggression. So these are really completely different cases. So thank you for the question, because I think this difference is worth emphasizing.
A remark, if I may? Miroslava Luzina, I'm part of the organizers team, and I think that the question that was asked was not sort of adequately handled by our distinguished speakers, who hold certain things for granted because they know Ukraine well, but not all the audience knows Ukraine well. And the misconception I'd like to address is the one that Russia gave some assets or some industries to Ukraine. Russia has not come to Ukraine as to a savage land where there was no learning, no academic life, and it has not brought some, higher education, etc. First of all, this was the Soviet Union. All of the republics that comprised the Soviet Union were contributors to GDP. That's the first thing. And second is Russia as an empire has actually drawn from the source of Ukrainian learning back in the 17th century. Academic life in Ukraine, homegrown academic life, is earlier historically than it was in Russia. So to say that somehow Russia might be claiming that it has come to Ukraine and given it something, I'm sorry, this was not so. Ukraine has given to Russia not less than Russia has given to Ukraine, and during the Soviet times, those were different regions of the same, like of a large country, and we have earned those assets, sort of. They are ours.
Yes, and then one last question for the gentleman, and we shall have to close the session.
My name is Archibald. Basically, I wanted to find out from you, with this debate, where do you stand on the future of Europe's energy security, given that a pipeline needs to go through Ukraine from Russia? And so will these negotiations take that into perspective? Thank you.
That's an inevitable question.
This discussion can take more than this session too.
Absolutely.
At the same time, again, this another misconception, that you voiced here. Everybody believed that Ukraine could not survive without Russian gas, and then it was just an only choice for Ukraine to get gas from Russia. As we successfully proved in 2014, that Ukraine can get as much gas as it needs from the European market. And also, again, in Europe, you don't just have a functioning rule of law, you also have a functioning market. Actually, these two things are really like intertwined or interdependent, but you have a functioning market, and if others can buy from this market, Ukraine can also buy from the same market.
Can you do without Russian gas?
Again, so Europe can do without Russian gas. It's not an issue at all. First of all, again, I am a gas professional, so you have LNG terminals that are used, utilized at around 35%. So you can get much more LNG if you need, again, if Russia stops supplying you gas. Yes, maybe it will, in the short term, will cause some price increase. But it won't be detrimental, especially given the price decreased in the last couple of or 5 years or so. Also, Europe has more than enough potential to use less gas in general. For example, Germany decided to stop nuclear energy, and that's why they increased demand, for example, for Russian gas. Probably not, again, speaking for the long term, of course, you should probably more rely on renewables, but even with the current pace of renewables, it's more than realistic for Europe to refuse from any fossil fuels, not just natural gas, by the end of the next decade. And to some extent, you have this responsibility to lead, again, as probably the most developed part of the world in terms of decarbonization and transition into a decarbonized world. And you can show by your own example that by getting rid from, again, fossil fuels produced usually, or in many cases in countries with high political risk and with some questionable rule of law, through this basically initiative, you can ensure a much more sustainable business environment both in Europe and all over the world.
And Yuriy, as far as I remember, there were some recent announcements about new gas fields discovered in the Northern Sea, somewhere off Shetland Islands.
Yes, I mean, Norway is an important producer, and they can increase their production, especially with advance of new technologies. There were also recent discoveries in the Mediterranean Sea, again, in some EU countries, and, for example, in Israel, or, again, close to Cyprus. So Europe has potential to increase gas production. Europe has potential to increase, like, 10 times at least, basically, production of biogas, so from, again, renewable biosources, and to replace, for example, the decline in Groningen field in the Netherlands. But what I'm saying that it's really like a myth spread by Russian propaganda that Europe depends on Russian gas, and there is nothing Europe can do, but they still need to work with Russia. That's a myth, basically. There is no economic need for Nord Stream 2. Nord Stream 2 is a politically driven project with one particular aim, is to kill Ukrainian source of transit and to channel this money to corrupt European politicians, so that Europe is divided, weak, and reminds Russians or the Russian regime, as Mr. Kiselev said, of their familiar environment, where there is no rule of law and just corrupt politicians.
Let me give you the numbers. Ukraine now consumes 33 billion cubic meters a year. 30 years ago, Ukraine consumed 130 billion cubic meters a year. That's how much that has been saved already. Ukraine's production has been almost constant for 30 years at 20 billion cubic meters. Ukraine can easily produce 30 billion cubic meters and be self-sufficient in gas. And we have been saying this for the last 20 years, that within 5 years Ukraine can be self-sufficient in gas production if it lets in foreign companies. No foreign companies are there. And therefore this is not being developed. Modern technology is not being utilized fully. You have essentially for local businessmen plus Naftogaz that are producing gas. This can be done in quite another measure, and reformers, including in Naftogaz, are trying to develop that. And with regard to gas pipeline capacity, it's about approximately twice as large as it needs to be. So Gazprom now transports about 90 billion cubic meters per year through Ukraine. The capacity is 160 billion cubic meters a year. And there's also other free gas pipeline capacity. So Nord Stream 2 is a purely political project, plus that Timchenko and Rothenberg, Putin's friends, need a few billion extra for their personal financial situation, which is not good, but not sufficiently good. And this is the real purpose of Nord Stream 2, and take away $3 billion a year, which is 3% of GDP, Ukraine's GDP each year in transit fees. And this is essentially free money because it costs only $250 a year to run the transit pipeline through Ukraine. Sorry, thank you.
I'm sorry, we have to wrap it up, friends and colleagues. Okay, this is the last. Because we have expired.
Thank you very, very much for opportunity. So question is of super pragmatic nature. Going back to 1990, 1991, if my information is correct, when Soviet Union collapsed, how Russia divided assets and liabilities among 15 republics. All assets belong to Russian Federation. Automatically, all liabilities spread among 15 Soviet republics to other nations in the world. Was something done about it? Is this information correct?
No, it's incorrect. Russia took all the debts.
That's an article I read, and I was curious.
Yeah, I mean, this is a Ukrainian myth, I'm afraid. And Russia took all the assets, meaning the Soviet buildings abroad, which was very little in comparison with the debt that was more than $100 billion. So these are people who think that a few buildings abroad are worth a lot and Ukraine should get its share of it, while the Soviet foreign debt was far more. And when it comes to assets on the ground, everything was given to the republic in question, with the big exception of Sevastopol naval port that was leased by Ukraine to Russia in a not very successful fashion.
I am afraid that the issue is much more complicated, and definitely there were a number of attempts to solve this issue, and there were a number of investigations, including journalist investigations, how it happens and why this issue was not solved, but it's still pending, and definitely we have to think about this in future, not now, while we have another more emerging problems. But I do believe that you pointed out quite a right point, but with a very, very long and complicated history.
Well, I'm afraid the time has expired. Organizers of the event asked me to inform all of you that you can have coffee on the third floor.